go ahead and go on the record. State of Idaho versus Mark Jason Bent. CR 1022-8186. I have Randy Neal on behalf of the state. I have Mr. Bent here along with his attorney, Sarah Stavinsky. We're here for a sentencing following a jury conviction in this matter. Mr. Stavinsky, are we proceeding with sentencing today?
We are, Your Honor.
All right, Mr. Neal?
We're ready.
All right. All right, Mr. Bent, we are proceeding with the sentencing following a jury verdict that was entered December 16, 2024, when the jury found you guilty of murder in the first degree. They also found that you had used a deadly weapon in the commission of a crime. Following that jury verdict, I did order a new pre-sentence investigation report be prepared, as well as a psychological evaluation. They were both prepared. The PSI was filed February 3rd, 2025. Mr. Bent, did you have an opportunity to review that document?
Yes, Your Honor.
All right, Mr. Stavinsky, anything in there that needs to be corrected or clarified?
Yes, Your Honor. So on page 6,
Okay.
and it's in the first paragraph, there's a sentence that begins, I felt like my reputation was personally tainted in this event because of him.
I see that.
So instead of personally, it should be permanently. So
Right.
the sentence should read, I felt like my reputation was permanently tainted in this event. And then on the same page 6, last paragraph, the sentence is, I was still going to work in Idaho Falls, but didn't feel safe being vulnerable in my sleep on learning my house to be broken. So the word should be leaving. So being vulnerable in my sleep on leaving my house to be broken into.
Okay. I will make those changes. Any others?
Yes, on page 8, fourth paragraph, there's a sentence that begins, I was still listening to some secular rap and heavy metal until I was introduced to a prison ministry podcast called Hip Hop Hope that talks about how, so the sentence continues. So the actual sentence should be, instead of Hip Hop Hope, it's Real Vida, and that's actually mentioned down in the same paragraph. But it's so it's called Real Vida, and then also the podcast Hip Hop Hope.
And I just need to add, because Real Vida is mentioned below.
Yes.
All right. Okay.
And then on page 9, third paragraph, and it says, one of the people that Christopher Terry contacted before the trial, and it says here Lucro Chavez, that should be Lucio Chavez, should be Lucio.
Okay.
And same page 9, the sentence, John Thomas has been saying I was looking at 10 to 25 years. It should be 10 to 15 years. And it kind of tracks with, there's a statement just a couple of sentences down where it says, I asked him about it 10, 15 years.
All right. Make those changes.
And the only other two, so we did submit earlier today psychological evaluation done by Dr. Hatzenbuehler, and also 3 certificates of completion for the courses Mr. Brand has taken when he was at the Bonneville County Jail.
And I will note for the record, those were submitted, and I did get an opportunity at lunch to review all of those.
Just so we just ask.
I didn't see any.
You didn't see the additional certificates?
Yeah.
Self-help booklet, managing anger, a self-help booklet dealing with conflict and anger and MRT, how to escape your prison class. And I think the MRT was referenced as part of his PSI.
Yes, Your Honor. And I think some of them were filed in the previous PSI, but we just want to make sure we have all of the certificates.
Well, I would also note that there was an addendum to the PSI filed February 3rd that included 74 pages of certificates that were completed by Mr. Bent. That was filed also.
Thank you, Your Honor. That's, we're just asking the court to include those two filings with the PSI packet. Other than that, that's all we have. Your Honor. Thank you.
All right, any objection to me relying on the PSI and these additional documents for sentencing purposes?
No, Your Honor, no objections.
All right. Mr. Bennett joined us yet? Do you have Mr. Bennett yet? All right, we don't have Mr. Bennett.
That's fine, Your Honor. We'll just proceed. I mean, there is a letter from him in the PSI. So.
And I did review that. Mr. Stavinsky, turn the floor to you for comments, recommendation.
Well, Your Honor, I think it's fair to say that this is one of the hardest sentencings that many of us have seen in a long time. We appreciate the comments from the parents, and looking through this case, Your Honor, from the beginning, Mr. Ban he actually called the police on his behalf. He waived the preliminary hearing. He was really attentive about going through his case file, going through all the discovery, talking to all of his attorneys, exercise his Sixth Amendment right to go to trial. So everybody's entitled to have a fair trial, and he went to the trial, he testified. Obviously, the jurors has found him guilty, and he's accepting that the verdict. But I think it's important to note that even looking to the PSI, his LSI score is moderate. So also, if you look at the evaluation that Dr. Hassenbuehler has prepared, we're talking about a lengthy history of mental health issues, going back to his childhood. And unfortunately, they were not addressed. They were not addressed properly. Combination with substance abuse, and I think it was a big factor in what happened here. That's, I think if he had gotten proper mental health treatment when he was still young, we wouldn't be here today. The fact that he lived with his parents when he was in Washington, I think, helped him keep his mental health issues under some kind of control. Because really, things kind of went downhill when he moved to Idaho and started living by himself. And just the fact that he's lived with his parents until late in his years just kind of shows it that it's not somebody who was able to just live on his own. And that's due to his mental health issues. Bipolar disorder, he's got suicidal thoughts. In fact, he thought about just committing suicide right after he called the police, but his father actually talked him out of it. Had he gotten good help, professional help, had he gotten substance abuse treatment, because what basically his
mental health issues were not treated properly. He was on medication, but that clearly didn't help him. And you add marijuana and alcohol use on top of his mental health issues, on top of improperly prescribed medication that wasn't really helping him, created this event that's very, very unfortunate event. As Mr. Bent testified to, he could have taken it back, he would gotten help. Stalin also, when he was while incarcerated, he's taking steps to try to improve himself as much as possible. He's taking many classes, he submitted certificates for many of the classes he's taken, and he's trying to be productive. When looking at the sentencing criteria, the 2 Hill case, well, first of all, we're not even asking. Obviously, he doesn't qualify for probation, so we're not even going to be addressing that. I think the seriousness of the crime merits serious punishment. Rehabilitation, Your Honor, I think it should be on the table. Under 1925-21 and also the 2 Hill case, Mr. Band needs to be able to look forward to the time when he is rehabilitated. Obviously, the court has discretion to impose up to life in prison. At that point, as far as rehabilitation, it's probably going to be impossible to achieve because the only thing he can look forward to is dying in prison. I think considering the fact that he's called the police, he's taken steps to he's waived the preliminary hearing, even the fact that he's testifying trial, putting himself out there to the jury, the court, just shows somebody who's never actually run away from responsibility, but no matter how tragic event is, how serious the crime, we are all entitled to our Sixth Amendment. All people in the United States are entitled to a right to have a jury trial. And that's not something that should, by the state representatives or by the courts, should be used against him. Just because he went to jury trial, that should not be used against him because we do have our rights and protect everybody. And in any kind of situation. I think looking at the PSI, I think looking at the psychological evaluations, he can be rehabilitated with proper treatment. Eventually, he'll be able to go back into society and be a good citizen. Obviously, we'll be asking for give him prison time, credit time served, but of course, give him the opportunity to at least give him fixed time with a life indeterminate, and at least give parole board a chance to take a look at this case. Just because he's going to be eligible for parole doesn't mean the parole board will ever grant him parole. The parole board always looks at many factors, how he's doing in prison, while he's incarcerated. They'll notify the victims, notify the state, the prosecution. So there's many things that are involved in that. But I think to accomplish all the sentencing criteria in the 2 Hill case, he needs to be able to look forward to the time when he has a decent chance. The statute provides for minimum 10 years up to life. Your Honor, I think 10 years is a reasonable fixed sentence plus life indeterminate. And again, it's not something that's it's not something just like he's going to be just out in 10 years. It's just at least gives me a chance to prove himself to the court, to society, to victims, to everybody, that he can be rehabilitated. Otherwise, he's just going to be languishing in jail for the rest of his life. And again, I think this is the kind of case where he deserves to be able to be rehabilitated.
Thank you, Mr. Stavinsky. want to try and, can the person with the phone number 4402 identify themselves, please?
Hello?
Yeah, can you hear me?
Hello?
Yes, can you hear
Yes.
me? Who are you?
Yeah, I can.
Can you
Mark's
identify?
father, William Bent.
All right, Mr. Stavinsky, do you want to try and inquire of Mr. Bent or not?
Your Honor, I think
Because we,
Mr. Bent
did submit
a letter to the court. I think that should be sufficient for sentencing purposes.
Right.
I know William Bent wanted to be present here for sentencing, but I think with the letters in the record, I'm not going to call him as a witness.
All right, I appreciate that. I will note for the record that his letter was included as part of the packet that I reviewed, and so I have reviewed that, so. All right. Mr. Bent, I'm just gonna ask you to put your phone on mute for the remainder of the hearing, okay?
Okay?
All right, thank you. Mr. Neal, I'll turn it over to you for state's comment.
And Your Honor, and my client, Mr. Bent, does want to make a statement as well.
And I anticipated as such. I'll hear from the state first, and then I'll give Mr. Bent an opportunity to make his own comments directly. All right, Mr. Neal, go ahead.
Okay.
Judge, it has always been my philosophy that we do not penalize anyone for exercising a constitutional right. Nothing I say today should be construed as suggesting that Mr. Bent deserves some sort of additional punishment because he took this to jury trial. The risk that a defendant takes when they do go to jury trial is that, as opposed to having this much information, the court has a week's worth of detail. Not only does the court have all of that specific information and all of those various pieces of evidence and testimony that came in, the court becomes very familiar with the defendant, can watch his reaction, can see how he acts. In this particular case, heard directly from him explain what the circumstances were. And all of those things are well within the purview of the court to consider. Our recommendation did change based on those things that happened, that came out, and my recommendation is based on those things that are contained in the PSI that I find very troubling. Obviously, in a case like this, the severity is the first thing that stands out. I was struck by Tara's words today. We all can recognize that the reason that murder is as severe a crime as it is that it doesn't have a single victim. It has the starting point of the victimization. So Nik Bird is the victim of this crime, and yet the statutes recognize that the immediate family are victims. That is the rock being dropped in the pond. The effect that this death has had is something that has rippled throughout our community. It has gone beyond the family. It has gone to friends and loved ones. But Tara also talks about the victim having been affected more than that moment of the crime. That in this particular case, you have a 23-year-old man who will not experience many of the things, the greatest joys in life that some of us take for granted. The idea of having a family, of making those major milestones that come in adulthood. I mean, these are all things that indicate just why this crime is seen as the most severe. And Mr. Bent was convicted of the most significant version of this, first-degree murder, which requires some aggravating factors. And so, as we look at what has happened with Mr. Bent in his life, perhaps, yes, his parents have had some kind of ability to keep him from acting out. But it's certainly something that has been demonstrated time and time again that Mr. Bent is a ticking time bomb. As we consider the factors that this court must apply in getting an appropriate sentence, obviously rehabilitation is something that's been argued by the defense, but deterrence and punishment for the severe crime that we have, I mean, that plays the factor. But no factor is more significant pursuant to the case law than the protection of society. And in this case, Mark Bent presents a continuing threat, a continuing danger to our community. We start with some early juvenile issues that began when I was living in Washington. In 2009, there was the interaction with a coworker that's described by Mr. Bent, both in the pre-sentence investigation as well as in some detail in the report that was presented by Dr. Hadson-Buehler. I think counsel's right. By the time that he was out on his own, most of the issues that had presented themselves based on his inability to get along with people at work. And then he would see these folks as causing him harm and causing him disrespect and causing him the necessity that he would have to quit because they had created such a hostile environment for him. In jail, he's had 2 disciplinary actions. One is for an extra sheet that he wasn't supposed to have, but the other one in April, while he was pending trial, he was sanctioned for fighting. In the report from the jail, there's the details that are contained on page 14, but one of the things that wasn't expressed in there is that once they got into this fight, they actually paused while a jailer walked by long enough so that they wouldn't get in trouble with the jailer, but then could return to the fight after he was gone. In 2022, he did have an opportunity to go to some counseling. This is page 14. He stopped going because, in his words, I believe, he wasn't being honest about his thoughts of killing Nick. Violence has been something that has been a recurrent ideation, sometimes to himself, but ultimately also, and most dangerously, he has had homicidal ideations. This included the thoughts that he described that potentially he would, and this was described in the Facebook post post that he put out right after he had shot Nik Bird, talking about that he had also contemplated the possibility of going to a car show where a group of car enthusiasts would be, and then potentially, becoming an active shooter there. That was reflected in his words on page 21. I would drive around the car shows where I knew he was with a gun, but I never did anything. As I review a lot of these materials, and this included a statement, began on page 4, goes on for several pages. Page 12, probably one of the longest statements I've ever seen by a defendant. There is a pattern of shifting blame. There's a pattern of finding justification for his thoughts and his actions. There's a pattern of trying to find excuses. There's a pattern of trying to minimize. There's a pattern of trying to make these comparisons to other cases, suggesting that he was somehow being wronged by the prosecution because they wanted a more severe penalty than others were getting. There was blame on everybody around him, that he wasn't, getting a fair shake, that, all of these things could be simply blamed on something else. This case is more severe for what went into it for months, if not even longer. The ideation of violence against not only one person, but a group of people. In fact, even in his statement, he remarks about when he arrived at the Albertsons after calling the police to turn himself in. He saw somebody from the car club, but he felt that his father had talked him down from taking out some form of violence against that person. So what this court has to consider is, what would that look like in a release in the future? If his parents are the guiding influence that has been able to keep this under control for these years, what will happen when those parents, who are significantly older than he is, when they pass on and they're no longer there? And then he would be released into our community, a ticking time bomb. This is a severe crime, not just because of this is a murder, a first-degree murder, but because this victim was stalked like prey. We watched a video where he drove for several minutes from Pocatello to Idaho Falls, according to his own words, intending to find Nik and confront him. At any point during that drive, he could have stopped, and he could have reconsidered, and he could have changed his mind. He didn't. He then is seen going from place to place where these car clubs normally, held their get-togethers. And at any one of those, this could have been a scene of violence. Instead, he finds Nik's car parked near, over by Saturn. But Nik is not there, and yet he waits waits like a hunter, waiting for his prey to return to that car. And then he develops a plan to distract him, to keep him outside of his car. He goes and he breaks that side mirror. He admitted that. He steps out. When Nick gets there, he could have easily let Nick drive away. By all testimony, Nick was having a pretty bad day. And then after all of these things, the ideation that began as early as months before, certainly as early as July, weeks before, when he wrote a confession of what he intended to do. Then he walked forward and he started pulling the trigger. Bang, 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 bang. Anybody with any humanity has difficulty going that long, pulling the trigger. And most of those shots, as testified by the medical examiner, while he lay on his side on the ground, helpless and certainly no threat at all. Most of those shots would have been fatal. But by the time he arrived in the hospital, there was absolutely nothing that could be done. He had absolutely no chance. And for what? And for what? And had that same opportunity happened somewhere else, what would have been the result? And what happens next time he feels offense? What happens next time he thinks that somebody has done something that permanently altered his reputation? Page 4 of the Dr. Hatzenbuehler's outlines that situation we were talking about. Where he was charged with harassment. Page 5 talks about attempting suicide twice in his life. Page 6, this is from Dr. Lander's report. Mr. Ben has struggled to maintain positive relationships with prosocial peers due to his tendency to be emotionally reactive, easily offended, and verbally aggressive when he was upset. He added that Mr. Ben's difficulties with anger discontrol have been present since he was a child and continued unabated up until the events leading to his incarceration. On page 7, he indicated that his victim was still alive when he left the scene, but he didn't think of calling 911. It is interesting that even though he claims that he wasn't in control when he was pulling that trigger that many times, that he can recall determining that he was still alive. Humanity screams, give this man a chance to survive, and yet he drove away. Profile suggests unstable moods, at times feeling apathetic and numb, and at other times demonstrating emotions of high intensity. Because he is inclined to blame negative events that occur on him on external factors, which is 9 pages over here, he is prone to express anger either overtly or covertly and may become uncooperative and hard to handle. page 9. Scored in the high average range of the cognitive subscale, suggesting that he has a propensity to experience thoughts that are anger engendering. These scores suggest that he is sensitive to the threat of mistreatment by other people and that he feels justified in expressing anger to the disrespect or unfair way in which he has been treated. Again, 9 pages. His cognitive score also just suggests that he's inclined to view others as having malevolent intent, making him ready to respond easily to others in an antagonistic manner. Mr. Bent also scored in the high average range on the behavioral subscale, suggesting that he is inclined to act in an antagonistic or confrontational manner toward the source of his perceived provocation. When stressed, he may be inclined to represent in anger due to his inability to come up with constructive problem-solving behavior. Finally, he scored in the low average range on the anger regulation subscale, which suggests that he has a less than adequate ability to regulate his anger engendering thoughts and to engage in self-calming behaviors when faced with provocation. This is a psychologically complex case. Even in the 70-some pages of completion, the risk becomes clear. These are some of those certificates of completion. The tendency, I think, is to think, well, he's been making use of his time to do these online classes. And there are many, past classes having to do with computers, the Bible. In December 5, 2023, he took aggression replacement therapy. His score was needs improvement. September 28, 2023, how can I stop my anger? Score needs improvement. September 2023, anger management, score needs improvement. Changing habits around drug and alcohol use, December 7th, score needs improvement. May 2027, God helps me manage my anger, score needs improvement. January 28, 2025, after taking these classes months before, anger management needs improvement. God helps me manage my anger, needs improvement. Changing habits around drug and alcohol use needs improvement. Aggression replacement therapy needs improvement. How can I stop my anger? Needs improvement. I consider it a true honor to stand here and speak on behalf of Nik Bird. But my ultimate responsibility is to speak on behalf of this community. And this individual presents a risk that is unacceptable. This is someone that has not proven in any of those steps that have taken place so far that he is capable of controlling his anger and his thought process. And in pages of documents, he describes all of those people who have either let him down, treated him wrong, and that's today. That's as we sit here today, even though this crime occurred years ago. for that reason, I'm not asking on behalf of the state that Mr. Bent not have an opportunity for parole. But I do believe that in this case, a fixed sentence of 30 years is necessary in order for us to protect this community. In that time, maybe Mr. Bent will have those skills developed. If he doesn't, he will certainly show. And so pursuant to the statute, which requires it, he should have the maximum life sentence imposed. Again, these are based on all the factors that have been presented to this court, the way that he behaved when he was in the courtroom, the way he behaved when he testified, the words that he decided to submit to this court of the pre-sentence investigation. And it is consistent with the other factors, the factors of deterrent to himself and others, and clearly the penalty for what was an inhumane crime, the nature of which is just difficult to comprehend. It's just difficult to understand how somebody could get past that part of us, that no matter how angry we get, we would never do this. We would never be so disconnected with our humanity that we could continue to inflict that kind of damage. And after doing so, drive away. The primary concern that I've seen is with what happens to him now. What should have been prevalent, what should have been prevalent and isn't prevalent in all of us, is how do we avoid hurting people in this world? How do we control ourselves that we don't, in some way, create the damage that's represented? And I mean, ultimately, Judge, the question for this court has to be, how do we prevent that? How do we ensure that doesn't come back and haunt this community ever again? So that's the reason for our recommendation.
Thank you, Mr. Mr. Ben, you have an opportunity to make a statement directly to me. You don't have to make any statement at all. I don't place any negative meaning or inference on any defendant that chooses to stay silent at this stage of the process. But if you want to make a statement, what I would ask is that you speak up clearly so that we get an accurate record. Do you want to make your own statement?
Yes, Your Honor.
All right, go ahead whenever you're ready.
I'm very sorry for what I have done. I would do anything to take it all back. But I can't change the past. All I can do is use this experience, or try to use experience to help others, to try and prevent similar incidents. I share my experience, strength, and hope with people in LDS 12-step and AA meetings, at the jail, as well as Bible studies, in hopes that it will help others. And I plan on continuing that in prison. I pray for Nik's parents, friends, and family every day, and I hope that they can forgive me. Thank you.
Thank you, Mr. Ben. Mr. Stavinsky, is there any legal reason I should not impose sentence today?
No, Your Honor.
All right. Mr. Ben, based on the jury finding of guilt, it is the judgment of this court that you are guilty of murder in the first degree. As indicated earlier, the jury also found that you used a deadly weapon in the commission of the crime. In preparation of today, I did go back and I looked at the entirety of your file. That includes the pre-sentence investigation report. That includes the certificates of completion of the classes you have taken while you've been in custody. That does also include the evaluation report from Dr. Hatzenbuehler that was filed just today, that was referenced, as well as other factors. For every sentencing, Mr. Ben, I must keep in mind the objectives of sentencing that have been outlined by the Idaho Supreme Court. Those objectives include punishment, rehabilitation, protection of society, and deterrence for you and others. I also look at the factors contained in Idaho Code 1925-21. Those are factors that a court has to review when placing somebody in incarceration, or whether or not there would be some sort of probationary term. By statute, this is an incarceration case, so the question for this court becomes the amount of time that I feel is appropriate given all the factors. I'm going to start my evaluation by indicating to you, Mr. Bent, that your right to proceed to a jury trial had no bearing on my determination today. Every individual does have that right. It may be painful for society sometimes, painful for you, your family, certainly painful for Nik Bird and their family. Those constitutional rights are in place for a reason, and at no time does this court ever take into consideration the fact that a defendant exercises that right. I think it was clear once you took the stand in my mind as to the reasons why you proceeded there. Felt like you needed to tell your story. And you, all other factors being what they were, felt that that was an opportunity to do so. So just so you understand, the fact that you took this matter all the way to a jury trial with no bearing on this court's decision. I do want to note some things that are pertinent in my decision, some of which have been outlined by you, your counsel, and the state, some that maybe have not. These are aggravating factors, some of them are mitigating factors. There are some mitigating factors. You did, in fact, call 911. Certainly had the opportunity to leave and not turn yourself in. Turn this case into a whodunit. You did not do that. You called 911 and reported on yourself. You have stated remorse. I think there is some remorse that you feel now, Mr. Bent. The unfortunate part is it took the act of killing and taking Mr. Bird's life to feel that. Difficulty is that most individuals, when they get angry, they feel remorse for that anger before they act out on that anger. That did not occur in your case. But I think as we sit here today, I think you do feel some remorse for your actions. You did accept responsibility in your own testimony. I understand that you don't have a recollection of the seconds that were involved in pulling the trigger. I don't know. There's trauma-induced amnesia. War veterans have it. I don't know if that's going on or not. But you had a clear recollection of the events up until that point. So you have accepted responsibility. I think that's a mitigating factor. You have, in fact, applied yourself to various classes while incarceration. I did note some of the things that the prosecutor addressed, some of the anger classes where it showed you need improvement. All right. The question is, are you going to apply yourself in the future to get that improvement or not? I don't know the answer to that. I think only you know the answer to that. But you did at least attempt to take those courses and apply yourself. Your LSI score is a 28. That's a statistical measure, Mr. Ben, as to whether an individual is statistically likely to commit crimes in the future. You sit in the medium range. This is your first felony. You do have family support, which was noted based on the letters that were received, and your father is attending this hearing by Zoom. You completed MRT in jail, and I think that that is a significant course with respect to criminal thinking and errors, and trying to give an individual who completes that course the guidance when they're faced with difficult situations in the future. You do have an associate's degree, and you do have employable skills. And I know that you were working on your addiction issues. I have to weigh those against aggravating factors. Obviously, the most serious aggravating factors, you took a man's life. Aggravation on that factor is the manner in which you took the man's life. You had stewed in anger. That's clear based on the conversations you had. You sought out friendships or relationships through these clubs. And when it didn't work out, instead of just walking away, you walked away with anger, and yet you never fully extricated yourself from that situation. You thought these people were speaking ill of you. You thought they were identifying you as an undercover police officer or a narc for the police. You couldn't just slough that off and let that go. You had to continue to engage Nik Bird in social media dialogue. But you also had to continue to watch that social media. And if anybody wants to do a case study on the problems with social media today, this would be one of them. Where nobody seemed to let it go. And everybody seemed to feel emboldened with comments and actions, and you to an egregious manner. You drove all the way from Pocatello feeling that anger. And after having consumed alcohol and smoking marijuana, clearly in a bad headspace. It takes, 40, 50 minutes to drive from there to here. And you apparently, whatever anger you were feeling, could not let go of in that drive. Got to Idaho Falls, you drove around Idaho Falls, going to locations where there were car clubs, looking for Mr. Bird, located his vehicle near his home, and you waited. You broke his side view mirror, and you waited. You authored at least, I think there were two, based on the testimony provided, 2 social media posts in advance of the events. One was to your parents, and one I think was a general statement to friends. Sometimes it's cathartic to write down our feelings, and then we can let them go. In your case, you wrote down your feelings and you wrote down your plans, and you never let them go. And you acted out those plans, and then you actually sent the posts after the event. You talked about the impact on the Birds and their friends. Clearly, Nicholas has support here. You also have support. This is an impact that doesn't just affect them. It affects you. It affects your family, it affects your parents, it affects anybody that you knew growing up. This is one of these crimes and circumstances, as Mr. Neal referenced, it's a drop in the pond. That ripple effect is not just contained in this small room and in this building. It ripples out to family, to friends, to the next generation, to the community, because the community will obviously read about this in the morning news, and it will have an impact on them. So there's an aggravating factor that's involved in that. This is one of the few, if only, crimes where the victim has no opportunity to go on. If there's a bar fight, and there's a victim of a bar fight, there may be a surgery, there may be maybe counseling, because now they feel afraid or intimidated, but they have the ability to go on and try and get past whatever that event is. Remove that possibility from Mr. Bird. Shot Mr. Bird multiple times. I think if we had a situation, Mr. Bent, where you were so angry and you saw Mr. Bird and maybe you reacted and you fired your weapon once, whether it struck Mr. Bird or not, and then you stopped, came to your senses, you're probably having a different conversation, even if Mr. Bird died. The result is the same, but how he got there and what you did to get him there, I think would be a different conversation. You did try and go to counseling for this in 2022. You went to one counseling session, you stopped because you recognized you weren't being honest with the counselor as to the reasons why you were going to counseling. So you had opportunities to be honest about your feelings and truly seek help, and you walked away from that opportunity. Both Dr. Landers and Dr. Hatzenbuehler, in their evaluations, discussed your anger issues. Dr. Hatzenbuehler noted that you have paranoia type concerns with respect to social media, people criticizing you without cause. Again, if there's a social studies or a case study with respect to social media, I think this would fit in that category for what is presented in social media and how people react to that. You could not let that go. You indicated that you had been arguing on the internet for 10 years using social media, again, with the inability to let that go. You felt like an outcast growing up. You have been diagnosed with major depressive disorder, alcohol and cannabis use disorder, bipolar disorder, prone to impulsive behaviors, propensity to experience thoughts that are anger endangering, low average on anger regulation. If something had been addressed in the past, then maybe this would have been controlled. Unfortunately, it was not. Nobody wants to be here, Mr. Bent. You would poll the entire room. Everybody would rather not be here because this event never happened. But we are here, and we are here because of your actions, and your inability to control anger towards somebody, and especially when we look back at the conversations that were going on through social media that had happened months before. This wasn't even you reacting to an immediate statement or perceived threat. This was something that had happened months and months before, and you just let it stew and fester. So with that, Mr. Bent, for all of those reasons, for all the objectives of sentencing that I am bound by the Idaho Supreme Court, it is the judgment of this court that you be sentenced to the Idaho Department of Corrections as follows. For count 1, murder in the first degree, that you be given a 30-year determinate period of incarceration followed by a life indeterminate period of time. In addition to that, you will have, because of the enhancement, the additional 15 years for enhancement. There will be a fine of $5,000 plus court costs. There will be a $5,000 civil penalty. While you're incarcerated, given the evaluations from Dr. Hatzenbuehler, I'm going to order that you seek treatment for the mental health issues that have been unattended for all these years, plus the substance abuse issues. You will be required to reimburse the public for your attorney services in the amount of $1,000. Mr. Neal, I've noticed that there have been several motions and amended motions for restitution, and I gotta be honest with you, I'm a little confused as to what's up to date and what's not, so I am going to hold off on restitution. I'm gonna ask the state to review the various motions for restitution, including the one that was filed today, and get an updated motion for restitution. Provide those to Mr. Bent and counsel, and then we can schedule another hearing if we need to. But because of the various filings, I don't want to misspeak and order an inappropriate amount of restitution, nor do I want to do so without giving Mr. Bent an opportunity to review this. Mr. Stavinsky, anything I need to clarify or I did not address?
Judge, we did file a motion to apply his inmate worker fees towards any fines and court costs.
That will be granted, number one, and number two, he will be given credit for the time he's already served. I did not mention that. Anything else I need to clarify or I did not address?
No, Your Honor, thank you.
Mr. Neal, anything I need to clarify or I did not address?
No, Your Honor.
Mr. Bent, do you have any questions with respect to the sentence I have imposed?
No, Your Honor.
All right. Indicated it gives me no pleasure to issue that sentence. I would rather we not have to have this conversation. With that, Mr. Bent, I need to advise you that you have appellate rights that now attach to your case. You can appeal my decision. You have 42 days to file that appeal. If you think my decision is illegal or too harsh, you can also seek relief under Idaho Criminal Rule 35. You have 120 days to seek relief under that. Lastly, you have the ability to seek relief under the Idaho Uniform Post-Conviction Relief Act. You have 1 year after your appellate rights expire to seek relief under that act. You have a right to have an attorney assist with all of those appeals, and if you cannot afford one would be appointed. Do you understand your appellate rights?
Yes, Your Honor.
Do you have any question of me with respect to your sentence or your appellate rights?
No, Your Honor.
Mr. Stavinsky, anything else I need to take up today?
No, Your Honor, thank you.
Mr. Neal, anything else?
No, Your Honor.
All right, with that, then, Mr. Bent, I will remand you to the Bonneville County Sheriff. You will eventually turn you over to the Idaho Department of Corrections to serve your sentence, and with that, we are recessed in today's matter.
All rise, please.